Well, you know what? Joan SHIFFLET welcomes everybody to Breath Matters. It's so good to see your smiling faces. And you know what's really cool about Zoom is everybody can see the smiling faces that I only get a chance to see at our face-to-face meetings. So now you can see why I'm always smiling because that's what I'm receiving when I'm standing up there in front of everybody. Um, to respect Joe's time, I'm going to let Joe go ahead and get the ball rolling with his presentation. I did a little bit of an informal intro, but I'm not going to do any formal intro. But Joe and his team, I personally trust and respect. I personally trust and respect that if there's anything that their team cannot handle, that they will graciously lead anybody in the proper direction to get whatever guidance that they need. It really works extremely well for me to have his team supposedly in my back pocket. You hear me say that all the time. I don't put everybody in my back pocket, but it is important for me to share those that I do, and those are individuals or teams that I highly respect. With that being said, I'm going to turn this over to Joe. At a very high level, we asked him to talk about wills, power of attorneys, and estate planning, but it's really going to be created via the energy and the knowledge that you're hungry for. So Joe, I'm going to turn it over to you, my friend.
All right.
Okay, Joe, as you get started here, I'm going to mute everyone, and then you'll have the floor if we don't.
Well, Don, if it's okay with you guys, whenever, if I'm at a point and somebody wants to just jump in and ask a question, that's fine. So I don't mind being interrupted like that. Knowing my limits, I didn't do a PowerPoint. And so if there's a dialogue somebody wants to have, I'm perfectly happy to do that.
Okay, we can try it. A lot of times if it starts bouncing around a lot though.
Well, if it gets to be a problem, then we'll let you take control, Don, because I don't want to mess up. If I try to be the host, I'll just cut everybody off and we'll be back in here. So,
Joe, I do have a leading question for you.
Okay.
The question I have is this. There is an understanding that out there in the public that you don't need a will. If you're going to leave everything to your spouse, I don't need a will. How do you answer that?
Well, what if spouse predeceases you? Then where are you? I mean, that's the big question. We don't know. I'm working with some folks right now who the husband had been suffering from Alzheimer's for years. Fortunately, we've done a will and had all that set up, but we're getting ready to probate. And the wife, who was the primary caregiver of her husband with the Alzheimer's, died first. And they weren't expecting that. So it can happen. We don't know at time. I've had 2 heart attacks, had bypass surgery twice. The over-under on me was 60. I beat that. I'm glad I lost the bet. So you just don't know. So I would, to say I'm leaving there, I want everything to go to my wife, but what if you have children? If you've got children and you think by not having a will, you're going to leave everything to your wife, you're not, because the children get a share of the estate. If it's one child, it's 50-50 with the wife. If it's 2 or more, the children get 2/3 and the wife gets 1/3 if there's no will. So to say I'm just going to leave everything to my spouse, and I don't need a will to do that, that's not totally accurate. Now, there are some things that happen automatically with a spouse. Let's say you own real estate together. Most people own real estate as tenants by the entirety with right of survivorship. And what that means is the property goes to the surviving spouse, whichever spouse is left after the first one passes. But then again, you have the situation of what happens after the first one passes. If you name spouses as beneficiaries of your retirement funds, they would go outside of the will. But to just simply say, I'm leaving everything to my wife, therefore I don't need a will, is not correct. Let's talk about, in fact, that was actually the first point I was going to make about, do I really need a will? Let me go into that a little deeper in terms of the notes that I made for that. If you don't have a will, let's say your spouse has passed, you don't have a will, but you have 3 children. The children can't sell the house without probate.
Joe, go ahead and unmute.
Am I there back?
Yeah, you're back now.
Okay.
I'm sorry.
Okay.
I was getting a lot of feedback and I went ahead and muted everyone else. I got you too.
Yeah, okay. What was the last thing you heard me say?
That
I don't know how I was talking about while I was muted.
Go ahead and start.
Okay.
Before you start back, I'm really getting a horrible connection here. I keep getting a message saying my internet's unstable. Is everybody else receiving the audio good?
Yes. I am.
Okay, I'm going to get off of here and try to dial in and listen to it over the phone.
All right, that's a good idea.
Okay, bye everybody.
But okay, Joe.
Okay. Let's talk about what happens if you don't have a will. One of the things that you do with a will when you have a will is it gives the executor, who's the person that goes in and takes care of administering the estate with a will, the right to sell real estate. If you don't have a will and there's real estate for the deceased, then you have to go through a court proceeding to get an order that allows the administrator to sell the real estate. So those things are taken care of. The second thing that's really important is the administrator will have to post a surety bond if there's no will saying that the surety bond is waived. So if you've got let's say a $500,000 estate, the estate's going to have to pay $2,000 to $5,000 in a fee to a bondsman so that there's a surety bond for the administrator of the estate. So you add expenses to the probate of the will or probate of the estate. Now, the other thing too to keep in mind is where does the property go if there's no will? We talked about the situation if there are children and you had wanted everything to go to your spouse, then if they're children, if there's no will, then a portion of the estate goes to the children and not the spouse. So you've got to look at that piece of it. But if a person dies and has no spouse and no children, then the property goes to their parents, if their parents are alive. If the parents aren't alive, then it goes to their brothers and sisters. And then if there's descendants from the brothers and sisters, I've had estates with families that had no wills where you had to track down 20 different nieces and nephews so we could sell a piece of property. So if you got a will and you take care of all those things, it makes it much cleaner and less expensive and easier to administer the estate. But so I would very much recommend getting a will. Now there's several types of will. One is the regular will. I leave everything to my wife. I leave part to my wife and the rest to my kids. We're all familiar with. And then there's what we call a pour over will. Now, a pour over will says everything I have that's not already in my trust, I'm gonna put in a trust. I'll talk more about trust here in a minute. And the final type is where a lot of young couples do this. They set up a trust within the will in case both parents die, and as sometimes happens, and the children are left as orphans or without parents. Then it's set up so there's a trust for them when they're still young, so that the parents' estate is held for them, pay for their education and those types of things. So we can put those kind of provisions in a will. A second major key in looking at documents is a trust. A lot of people say, I don't have enough to be worried about a trust. And yet a trust is probably the best tool to totally avoid probate that there is, because you can put everything in trust or name the trust as the beneficiary of everything, and you don't have to go to court at all if you set up a revocable trust. And you can make the same provisions for your heirs in setting it up as you want to go along with the trust. And the trustee doesn't have to go probate. You don't have to pay the probate fees. People don't understand. They think, well, I want to avoid estate taxes. Unless you've got an $11 million estate, you're probably not going to have estate taxes anyway, but it's like $100 $1,000 that the county charges you to handle the probate of the estate. So that can add up pretty quickly, several $1,000s when you go down to qualify as the administrator of the estate, depending on the amount of assets that are going to be managed by the administrator. So trusts are worth looking at. You can either have a revocable trust. Now, a revocable trust is just like you still own the property. You can buy, sell, you can invest, you can do anything you want to if you set up the irrevocable trust that way. And something to keep in mind, though, people think, well, if I put everything in this revocable trust, then my creditors can't get at it. That's not true. The only way you can have things in trust that the creditors can't get at is an irrevocable trust. And most people probably don't want that, because that means you don't have any control over your assets. So you would only want to do that. People do it for two reasons. If they do want to keep things from a creditor, they use them. But the second reason, everybody says, well, I don't want to use all my assets if I go in a nursing home. Well, the Medicaid rules are, and this keeps changing. So the last time I had to work with somebody going into Medicaid, there was a 5-year look back. So any asset that you gave away or put into a revocable trust within 5 years of needing to go into Medicaid does not keep Medicaid from requiring you to spend those assets with the nursing home. So you got to look at that, and it's got to be in an irrevocable trust for 5 years before Medicaid doesn't have a claim to it in terms of keeping somebody in a nursing home. And keep in mind, there's a difference between assisted living and skilled care. Medicaid does not pay for assisted living. It only pays for skilled care if you meet the requirements for skilled care. Then the Medicaid kicks in, it will pay. So those are a little more, I'm probably throwing out a little more than you were looking for, but trusts are a very useful tool. And particularly if you've got younger people that are going to inherit. Over the years, I've found that the younger generations aren't as physically responsible as older generations have been. And we used to set it up so that the young people could get their share of the trust when they were 25. Now we do a 3-tiered approach where they get a third at 30, half of the balance at 35, and the balance at 40, which means they get things from the inheritance at ages when there's usually significant events like buying the first house, getting married, having their children, things like that, where they'll need additional money. So, those are just some things to keep in mind about that. Does anybody have any questions about what I've said so far about wills or trusts? Would you let Don know?
They can unmute themselves.
Okay. Have I generated any questions for anybody?
Hello?
Hello?
Yeah, can you hear me?
Yes, sir.
This is Billy Williams. Yes, how about bank accounts and payable on death? What comments do you have about that?
Okay. It's a very useful tool to set up your bank accounts that way so that there's a payable on death. What that does do is it keeps that account out of the probate process, either by the will or by, if you don't have a will, through intestate administration. So that if you have things that you have named people as beneficiaries, pay on death bank accounts, 401k, IRAs, investment accounts, those accounts go outside of the estate and they go directly to the person named as the beneficiary or the person receiving at death. And they don't become part of the estate. And it does keep the cost and expenses of the probate down. It lessens those because they're not considered by the clerk as anything the clerk of the court is administering, so they don't charge the court fees based on the things that were passed outside of going through the administrator or the will. So yes, that, and payment on death, or named beneficiaries, that trumps provisions of a will. So if you've got major investment accounts and you name a person the beneficiary of that, but you leave everything, say, to your children, if that person is, say, a friend or neighbor, that friend or neighbor gets everything in that estate. It never goes into the estate, you don't get it. So that's something to really keep in mind in terms of payment on death. Most people have set it up with their spouses on accounts like that, named accounts beneficiaries that way. Some people, if they have trust and they want to have everything in the trust, they will name the trust as a beneficiary or pay on death with the bank account. So it just moves on in. If you've got a situation where you don't have anybody you want to leave that full account to, or you want to leave part of the account to 2 or 3 different people, then you can make a trust to pay on death beneficiary of the account and how you want to choose to do that. Billy, did that answer your question?
Yes, sir. Thank you.
Mm-hmm. Any other questions?
I have a question. My name is Rose, and I lived in Rhode Island before I moved here approximately 2 years ago, and I had my will and trust and power of attorney done in Rhode Island. Is that
Yes.
recognized here? Is there any change? You know,
It depends on how it was set up. I've viewed many documents from other states, and some of them are consistent. Some of them need to be massaged a little bit. So yeah, it would be useful to have a local attorney review that to make sure it will still do in Virginia what it want done. Since you've been here 2 years, you would be classified as a Virginia resident, and the administration of the state would have to occur here.
Okay, thank you.
Yes, ma'am. Anybody else? I prefer questions
Joe,
because I can't see anybody.
Yeah, Joe, I have a statement that might generate questions by others. It's a little different. If someone has a first marriage and the Mr. and Mrs. Smith's name is on the deed, let's make the assumption that Mr. Smith gets married again for the second time. He did not take his first wife's name off of the deed. So what happened, he passed away. The second wife had to move out of the house because it had the first wife's name on the deed and it was never modified. Is that correct?
It would seem to me that would be correct. And the problem goes back to whoever handled the divorce and what agreement they made following for the divorce, for the property settlement or equitable distribution in the divorce. That would be strange to still have the deed with the first wife on there.
I know, it was.
Now, one thing most people don't realize or may not realize, that if you've been married for 10 years and then get divorced, the spouse has a claim to your Social Security, to a portion of your Social Security. So that is something that's by federal law. A lot of people don't realize that, but that is in fact the law about that. So yeah, if you get divorced and you want that house to go to somebody else, that's interesting. That he left the first wife on the deed. Because
Yeah, it was pretty nasty.
That deed's going to control.
Yeah.
Huh. Wow. I sure hope that firm didn't have anything to do with that.
No, not that I know of.
I'm thinking.
But I didn't ask who.
That's like Divorce Law 101.
I know, you're right.
I'm Barbara. I had one question.
Sure, Barbara.
we had our original will done many years ago, and the attorney that did it ended up getting disbarred. Would that have any bearing on our will?
Not if he did the will correctly.
We've had it reviewed, and I believe any changes we want to make, we would just go and have those done, correct?
Yeah, you could have a codicil done, yes. How many years ago did he do the estate planning
Oh, it
document?
was like 30 years, I guess. The children were young, I remember that. And we had since changed our executor to our son, who's now 45.
Yeah, yeah, you probably ought to just look at it and make sure it still does what you want done as far as your estate is concerned. Was it a simple will that left everything to each other and then to the children?
It was.
Did it
And
make
we
a
had reviewed, I guess, maybe about 8 years ago, 7 or 8 years ago. And the lawyer was, close by, one of the local ones. And he said everything looked okay. I think we might have made one revision then. And one was our executor.
right, did a codicil making your son the
Right.
executor?
Exactly.
Yeah, that's another, yeah. So you should be fine with that. The fact he was disbarred does not make the work he did improper, except for the case that got him disbarred. That was usually an indication that he did something wrong for that case. But,
Appropriate funds, I think.
yeah, that seems to be what gets most people in trouble, the trust account.
Mhm.
But yeah, so I would think that well, clearly the disbarment doesn't affect a legitimate will if he did it correctly when he did it. And you had it looked at and done a codicil and made the changes you wanted done. So I would guess you'd be fine with all that, with that.
Well, our son is a non-practicing lawyer, but I would guess he could probably review it too.
Probably. Is he from Virginia? Is he in Virginia?
Yes.
He should be
Passport,
fine.
Virginia.
Yeah. He would most likely be able to look at it. And he clearly is qualified to be the executor. There's no legal training is required to be an executor. A lot of people are executors that have no legal training. It's just somebody you trust to do the right thing and follow your wishes. That's the key, and have some reasonable financial sense. Somebody that can handle the numbers and do that type of thing.
Now, a friend of mine suggested that you have both children as co-executors, but I am not real comfortable with my daughter being a part of that. And I kind of nixed it, but she said that that's fairly common.
It's fairly common, but you got to know your children.
Right.
I mean, there are, in my situation, I've named one of my law partners because neither of my children are detail oriented and have decent financial sense. Our oldest son's a screenwriter, and he's very creative and has done well and won Emmys out here, but he wouldn't anymore be able to handle being an executor on a estate than the man in the moon. And our other son is a horticulturalist, again, very talented, but not financially astute. So I've got one of my young law partners who's the same age as my kids and knows my kids. And so I felt more comfortable doing that. So you really have to be realistic and not have blinders on when you're saying, well, it's my son, he'll do the right thing. Well, I've seen some sons that didn't do the right thing, or not even because they tried to, they just didn't know what they were doing. So, it's I played football in college and coached a lot of youth sports. And I often said, you wouldn't want to put a nose tackle at wide receiver. You got to look at what the kid can do and what his talent is and act accordingly. Put them in places where they can succeed and not where they're uncomfortable. So I think you're wise in seeing and recognizing the gifts your children have and utilizing it that way. There's nothing wrong with making that decision. You don't have to have every kid be part of the executive process.
Hey, Joe, this is Joan Stoller. I was just wanting your opinion of these software packages you can buy where you can like do your own will. Are they valid?
They're valid, but they may not do what you want them to do. I've seen those packages, and a lot of times they are not state specific, and it may not, if you don't understand the language, it may not fit your needs. So I'm not a big fan of those online packages.
Okay.
It's kind of like, I represent a doctor in a contract case, and he had written up the contract and it had some holes in it. And I said, you know, what do you feel like when your patients come in and say, I've been looking on WebMD and this is what I have and this is what you need to do for me. And he just started shaking his head. I said, that's what happens when you do your own contracts. Like a doctor going to WebMD or a patient going to WebMD and then expecting you to fix it. So
if you do one of those packages, what would make it legal? Is there something else you have to do to make it hold up in court?
Well, no, it's a matter of, is it executed properly under Virginia? Is it self-proven? I had one where I had to probate it and there was some issues with the witnesses. So we had to go track down witnesses that they had used because there was writing on the will that shouldn't have been there. And we had to make sure who put that writing on there, and it made it much more complicated.
Oh, okay.
By the time we got it fixed, it would have been much cheaper if they'd have had to draw the will up.
Just how to do it. Okay, thank you.
So yeah, but people do them. I mean, they think that they can get anything you want to off the internet, and
That's true. All right, thank you.
Yes. Any other questions at this point? I was just going to mention a couple of other something that a lot of people ask about is, should I have a power of attorney? And I think depending on your age group and how long you've been married, my wife and I have been married 43 years now, and she has power of attorney, and I trust her that she's not going to go empty the bank account. Younger couples, in terms of a general power of attorney, you got to be really careful, because if y'all aren't getting along, a power of attorney allows a person to sell real estate, borrow money, empty bank accounts, do anything as if it's you. So you got to be really careful who you're willing to give a power of attorney to. And sometimes as parents, if you're needing help in giving power of attorney to a child, you want to make sure, again, it's the child that can handle the financial responsibility of paying the bills and making good decisions with investments. So again, that's important. But probably more important for all of it is a medical power of attorney, a durable medical power of attorney, where if you're unable to sign authorization to receive treatment, you want somebody there that can do that for you. A lot of doctors are asking for that now, to have a medical power of attorney so that somebody can make those decisions. So that's something to to strongly think about, and may want to think about the medical power of attorney's first cousin, the Advance Medical Directive or living will, which says at a point in time when you can no longer give me effective treatment and I'm going to be kept alive only by mechanical or artificial means, I'm prepared to go. Most hospitals ask if you have one, if you're being admitted for any kind of procedure now, do you have an Advanced Medical Directive? And we have ours on file at MCV because that's where I go for my heart treatment. So that's there at MCV. And again, I trust my wife completely to make the right decisions on that. The other thing about a power of attorney, there are two, that you can have it either as a durable power of attorney or a contingent power of attorney. A durable power of attorney will survive if you become disabled and can't make decisions. A contingent power of attorney will only become effective if you become disabled and mentally incompetent to handle your affairs. But that requires certification from 2 doctors before the person you've given power of attorney to can actually act. So that's something to keep in mind. A lot of people just do the durable because they trust the person they're given the power of attorney to. And the same is true with the Advance Medical Directive. Does anybody have any questions about powers of attorney?
I don't have a question. I have a statement or maybe an experience. I had someone whose son was in an accident, 19 years old. He did not have an advance directive, and his parents ran into problems being able to help out with that need because he did not have a medical advance directive.
And that's particularly true. Yeah, it's so they almost always ask now if you have one when you're admitted for a procedure at any age.
Mm-hmm.
Serious accident and unconscious and can't make any decisions or communicate, then yeah, that becomes a problem. And they're with the Hippocratic Oath, they're required to do everything.
Does it have to go to the courts for an appointed entity?
Conservatory.
Yes, correct.
You can do that. And that's when you see all the lawsuits about, coming in and wanting to, be able to take a person off of life support and that type of thing after, months and years. So yeah, there is, you have somebody appointed as a conservator that's given that decision or ability to make that decision. So it is much cleaner, although I don't talk to many 19-year-olds about advanced medical directives. That's a little young for them about that. But those of us who are a little more mature, it is probably a time to think about it. We're reaching more mature ages. The other thing to keep in mind is an advanced directive is not the same as a DNR, which is a do not resuscitate. And all of us on this call are actually too young, I think, to be having a DNR. What a DNR is if you go into cardiac arrest, they will not resuscitate you. When you start getting folks in their 80s that are in frail health, when they put the paddles on and start trying with the CPR, they invariably break ribs. and sometimes make the person worse off than they were because they're fragile at that point in time. And that was the thing, for example, when her mother-in-law was at that point, my mother-in-law, my wife and her brother said they didn't want mother to go through that pain of broken ribs, because broken ribs are very painful and she was not getting up and around. So, but they're not the same. And if there's not a DNR, then the EMTs are duty bound to do everything they can to resuscitate you. That may be beyond what anybody was thinking about for today's topic, but I always see them going hand in hand with a lot of people think that the Advance Medical Directive is the same as the Do Not Resuscitate, and they're not. They're very different. Usually the general practitioners and doctors treating folks have a sense when a person is at the point in their life for a DNR, and they start talking to the family then. The other thing I would tell you, we had a huge misconception about hospice until we worked with them with their mother-in-law. They are not just for somebody in the last days of life anymore. They do a wonderful job of taking care of people that really aren't able to take care of themselves that well anymore. They were great coming in a couple of times over to the Hermitage where my mother-in-law was to bathe her and clean up and all kinds of things. They were just a wonderful help. And then at the time when my mother-in-law's pancreatic cancer got to the point that she was in severe constant pain, they helped administer the morphine to keep her comfortable until the cancer took her. So that's just another thing to be thinking about, that it's not just in the very, very last stages of life anymore. They're a very useful outfit, the hospice groups around. Let me take a couple of minutes here and just briefly go through the probate process, and so that you can understand what will happen after your loved one has passed. If there's no will, then a relative can go down right away, being a spouse or child, and qualify as the administrator of the estate. And that person has just about all the authority that an executor does. The one difference is the administrator of the estate is not able to sell real estate until the court is petitioned and the judge issues an order allowing the administrator to sell the real estate. That's a process that adds expense to the probate or situation that could be avoided if there's a will.
Excuse me, Joe.
Yes.
Just for clarification, you said they can go down and qualify. Are you meaning go to the court?
Yes.
Okay, thank you.
That's probably a little more basic question I should have answered first. All the local courts around here have a probate division, and that's who handles the estates. So there's probate clerks that will either probate the will or appoint a proper person as administrator of the estate. And there are some forms they want you to fill out before you get down there. There's an inventory form, there's a tax form, and there's a form that lists all the heirs of the estate that they like for the person going down to have filled out. You can pull those forms up online. We regularly help folks fill out those forms and get them ready for probate. But whether you're living in Chesterfield, Henrico, the city, Hanover, they all have a probate division that's their numbers are listed, and I have found that the folks in the probate clerk's office, folks that do probate, are very, very helpful and are very much willing to walk you through the process. In some ways it's been challenging with the COVID, but we've still had several situations where we've been able to probate estates and get things moving for the estate. Once you have qualified, then you need to set up an estate account and get a state tax ID number. And then you take all the cash assets and put them in that estate account. And from there, you'll pay bills, anything you need to pay on behalf of the estate, including funeral expenses, things of that nature. Now, a lot of times people end up having to pay the funeral home before they can qualify, because you have to wait until you get the death. You got to have a death certificate with you as well, originally the death certificate. And if you're probating a will, you have to have the original will. They will not probate a copy of the will. So you need to have folks know where the original of your wills are before they're needed. So then you go down to the courthouse and do that. And I have to check the dates. Within 90 days, you need to file an initial inventory of the estate, where you put together everything that's come under your control, the date you acquired it, investment accounts, bank accounts, real estate, vehicles, all the things that the deceased owned at the time they died that's going to be covered by the estate. Then within 12 months after that, you need to file the first accounting. Now, some estates, you can do a first and final accounting and cover everything, but there are some estates that will take longer to work out, and you can do a first accounting, and then when you're ready to distribute all the assets, then do the final accounting. You should wait, if you have any questions at all. People who have a claim for debt against the estate have a year after your qualification to present that claim. So if the estate owes somebody money, they can wait up to a year after qualification to bring that claim. So we usually wait, particularly if we don't know the folks, make sure we wait at least a year before we distribute all the assets, because the executor or the administrator will be personally liable for the debts if they give the money out to the beneficiaries and there's nothing left to pay off a debt that's brought properly within the year. So that's something to keep in mind as well. As I said, the court will charge fees based on the assets that are going to be coming under the administration of the estate, either by the will or as an administrator for an intestate estate. The estate taxes, for the government estate taxes, Virginia does not charge estate taxes. They just charge probate fees. And what the probate fees do is, when you file your accounting, each jurisdiction has a commissioner of accounts, and they review that accounting to make sure the money has been done properly according to the will or the laws of intestate succession. It's at that point in time that he will sign off, and once he signs off and says that the estate has been properly administered and is complete, then he'll sign off for you, and you can close out the estate. But he gets, the commissioner of accounts gets paid based on the court fees, and the court gets, the clerk's office gets a certain portion of it for maintaining their probate division as well. But as far as estate taxes for the federal government, right now, it's I think $5.7 million for each individual that they can leave without any estate taxes. So a couple can have almost, well, $11.5 million in assets and it won't be taxed. I don't do taxes, so I always send, if you got that kind of estate and have tax questions, I send you to the accountants to get that straight. So do these comments raise any questions for you?
Joe, I'm going to go back to something you said earlier before I forget it.
Okay.
The DNR. Most people do not realize, if they have a DNR, how important it is for you to have it readily available at your fingertips if the medics come in your home.
Right.
That could be on the refrigerator, behind a calendar, or on the back of the bedroom door. This is where the medics are going to look for it. If you say, it is in my file cabinet at my son's house, that's not going to work. Because they need to have it readily available for them to see it before they can follow it. Otherwise, step aside. They're going to do what they're supposed to do.
Be it intubating, the shock treatment.
And anything. Absolutely.
Some I have read, some places recommend, particularly for elderly couples, and nobody's elderly on this call, I don't believe, but they recommend putting it on the front door at certain places.
Absolutely.
So
if you put it on the inside of the front door, but not everybody wants all of their friends that are coming in to necessarily.
No, yeah. The big door, but yeah, yeah.
The other thing I wanted to follow up on was your comment about hospice. It is still to this day such a misconception that if you're on hospice, you're dying and you're giving up. But I'll tell you a recent story. So someone could be of what I call critical conditions, where they're so weak they cannot go see their doctor. They need somebody to come to them. Hospice does a great job of managing you medically in your home. You can still go to the emergency room if you choose. You can be on hospice, you can go off hospice, you can come back on hospice. Such a huge misconception, and we can go into more detail related to that at a different meeting.
Yeah, I my wife and her brother thought they had trouble getting their head around putting their mom on hospice, and she was on hospice probably 6 months, and it was wonderful. They thought, why didn't we do this sooner? Because a lot of the things they were running around trying to make sure got done, hospice did once they were involved. It made life so much easier having the trained professionals do that for them. So yeah, that's why I throw that part of it in as well. So I have finished my prepared remarks. I felt like y'all may be thinking y'all trying to drink water out of a fire hose because I hit you with so much. But does anybody else have any questions?
Is there any new laws related to estate planning? That's the first.
The biggest new law that came about in January was the Secure Act. Folks could set up their trusts and so that their 401k monies could continue to be held in the 401k accounts in a tax deferred basis until the oldest child, who was the beneficiary of these, reached their age of required minimum distributions. They changed that law and it went in effect in January that says that monies in a 401k must be distributed within 10 years of the death of the individual who was the owner of the 401k account. And so that meant even if the person died and the children were in their 40s, they'd have to take everything out in their 50s and pay the taxes then, where in the old days, it was when the oldest child got to 70 and now it's 72 if you're continuing to work and contribute. They could wait till then when they were in a more favorable tax situation of taking the extra income. That's been the biggest thing in the last year. That's biggest change as far as the estate planning laws.
Joe, another thing to answer for this group, there's a misconception about estate planning. Can you share? Someone said, well, I only have $10,000. I don't need any estate planning. Or is there some basic guidelines that you can give the group as far as estate planning and the smart things to do related to that?
Well, it does somewhat depend on the size of the assets and how the assets are held as to what they need to do. For each couple, there are a number of or family. There are a number of options, whether it be just a straight will, having the real estate set up. Another tool that I did not mention that's used now is a transfer on death deed. Some people are deeding their homes to their children to pass when they to go to, so that the real estate transfers on their death. That's a tool some are using to cut down on the probate as well. I think everybody at least ought to take the money and buy some time with somebody that does estate planning to look at their particular estate, because there are things that they can do to actually save money in the long run. So each person's situation is different, but I will honestly say, if your assets are $10,000 or less, just put somebody on the bank account. But you know, if you're starting to deal with having real estate, some investments, having retirement accounts, things of that nature, you really do need some estate planning. And whether you do it through trust, through a will, you're going to be better off by saying who you want to do certain things and where you want things to go, because it isn't that the state's going to take it if you don't have any of these tools. It's just the state's going to dictate how it goes, if that makes sense. A lot of people think if you die without a will, it all goes to the state of Virginia. It does not. But the state of Virginia will tell you, the law of the state of Virginia will tell you who gets it. I've got a situation now where a fella passed, hadn't gotten around to doing his will, and he wanted everything to go to his brothers and sisters because he wasn't married and had no natural children. But what his brothers and sisters didn't know was he'd adopted the child of a previous wife. And now that child, by the intestate succession, is getting everything. And the brothers and sisters aren't getting anything. So those are the kinds of things that if you haven't, and everybody thinks, well, one day I'll get around to it. Well, sometimes you never get around to it before you need it.
Thank you, Joe. Any other questions for Joe before he leaves?
I had a question about the rules and regs with hospice. The thing that concerns me is if you are under hospice, this is what I heard, you will not have a hospital admission. And supposedly no more aggressive treatments. They'll maintain the medications you have. But my feeling is then you would have to come off of hospice if you wanted to seek a hospital admission. Is that correct?
I don't know that for sure,
Yes.
but I don't believe it's true.
Well,
I think
what is true is that there should be some dialogue. If hospice is saying, and there's so many ifs in this answer that I'm sharing with you, every situation is going to be unique. It is not black and white for anything. So let me give you an example. If hospice says, for example, Mrs. Smith only has 2 weeks to live, if that's the case, then taking her off of her heart medication, taking her off of her high blood pressure medication is probably the best thing to do. There's no need for those meds. It makes no difference. There's no need to try to even get those meds into mom if she cannot even take them. So you see where I'm talking about trying to find the right balance?
Right.
If Mrs. Smith says, I want to go get aggressive treatment, I don't want to be on hospice, you can stop it right there. You can go get aggressive treatment. And so just because you go on hospice, it doesn't mean that you cannot. The guidance that they give you is talk to us first before you go to the hospital. And they're telling you that based on the evaluation that they've done for your loved one. If you ever have any questions related to hospice, you can pick up the phone and I will help you with that.
You know, I noticed for any procedure that I've gone for a test, they will ask you if you're under hospice. And my impression is if you said yes, you would not get the test or procedure.
It's not that you wouldn't get the test or procedure. They would have another step before they would do it. And that step is to confirm that in fact, you want to go back to aggressive treatment. So don't think that just because you sign up for hospice that you cannot change your mind and go for aggressive treatment. Now, what I can tell you, hospice is really good at providing you education as far as the pros and cons for whatever choice you are possibly considering.
I don't know if hospice is in different in different states, but we had my dad before he passed away in hospice in Delaware. And that was the question I asked before we signed up. If he needed to go to the hospital, could he? And they said yes. And he did. At one point, he did. It was a little strange in there because he was under hospice care and in the hospital, and there was a little bit of friction between the nurses and the hospice people. But he was only in for a few days for antibiotics for pneumonia. But he was able to go to the hospital and get treated and come home.
Absolutely. So here's an in the weeds thing. Everybody wants to take pride in what they're in charge of. So what happens is if hospice starts the care for the day, they're the one that has the envelope for all of the charges for that day.
Mhm.
What happens is if it goes into the hospital, then somebody's in cost.
Mhm.
I hate to tell y'all that, but that's really the way that it is.
I'm sure it is.
Somebody's always eating cost when there's a shared day of care.
Mhm.
That's why when you are in the hospital, if they tell you home health is going to come tomorrow, they can't come today because they cannot, there's only one entity that can have the cost for care that day under the insurance umbrellas.
That makes sense.
Mhm.
That makes sense.
Any other questions for Joe?
I just wanted to know Joe's contact information if somebody from Breathmatters wanted to contact him for more information or help with estate planning. How do we get in contact with you?
I will get all that stuff to Joan.
Okay.
But briefly, it's the law firm of Owen and Owens. My email is joan@owenowens.com. And the phone number is 804-594-1911.
594-1911.
Right.
Got it.
And
Thank you.
ask specifically for Joe. Let me back up. Okay, here's a June thing. So please excuse me. Joe is very busy, just letting you know. So what I do know is Joe has got he's got a fabulous staff. What I do know is someone like Wyatt that I really would like for him to come to a meeting one day. The things that Joe just spoke about, he is also an expert at that. And I know Joe is moving fast all the time. So I know Wyatt would do his best job to help anybody here at Breathmatters. Did I step over line in saying that, Joe?
No.
Okay. All right. Any other questions? Listen, you've got a lawyer right here at your fingertips. You better ask those questions now because when he leaves, then the clock's going to start working. He only charges $75 an hour. I'm just kidding. I could only say that to Joe. I'm so sorry, Joe.
That's all right. That's because you're going to make up the difference.
Right.
Joan's going to make up the difference between $75 and my normal hourly rate for any calls you make.
I have a question about the need for a trust, or if that's the best tool. Is there something in particular that would dictate that this person, a trust would be the way to go?
Most people that say to me that we end up with the trust, they say, we don't want our family to have anything to do with the probate court. And I said, well, okay, I can do that for you, but it's got to go through a trust. And we set up the trust to do that, and we put all the assets in the trust.
Okay.
And so you can avoid, that's the big thing. And a lot of people feel like they've got more control of where things are going and how it's going by having it in the trust and setting up in the trust certain provisions. They feel like they've got a little more control at this point than just leaving it with the will. So that's the biggest things. The trust will absolutely, if you put everything in there, you can totally avoid ever going to the courthouse about the estate.
That sounds like a plus.
Trustee? Huh?
That sounds like a plus.
It is.
So
It is.
let me applaud something that Joe just said. So if you have that trust, I'm going to highly suggest that everything you have, your life insurance, your 401k, your money market accounts, whatever, the beneficiary of that needs to be worded exactly the way the trust is written. If it's not, it doesn't fit into the trust bucket or definition or behavior of that trust.
And we give you a letter if we do a trust for you that explains who you got to go to and what things need to be moved. Sets it all out for you.
You mean like your investments or insurance or all that needs to go into the trust?
Right.
Okay.
If you talk to your investment advisor and your real estate or insurance folks, they have the forms for you.
Okay.
They will walk you through it.
Yep, absolutely. Just verify it that it's, I always suggest people to go back and review things to make sure it is set up the way that you want it to be set up. Things change.
Right.
Any other
Hey,
questions?
Yes, I've got a hospice question. Joe, who puts somebody in hospice? Who has that authority?
Generally, it's the family, but it also requires the agreement of the person.
Well, I mean, well, who is the family? I mean, is that the husband? Is
Husband,
that the
children, husband or children generally.
Well, I mean, does that take precedence over the desire of the individual?
No.
No.
Well, what if
If the person is able to make their own decisions, they can refuse hospice.
Okay. So once you get in, it just dawned on me that my sister I just visited is in hospice. I don't know how she got there. And because her husband, she said he had some dementia, even though I never saw evidence of that, but because he didn't never say anything. But so it just dawned on me, I don't know where the authority was to put her in there because she's not very happy right now.
Well, guess what? This is what I highly suggest that you do, is to ask her. If she says, I don't know how I'm on hospice, then she needs to call the hospice company because somebody signed the papers of legal right to do that. So if she has made someone in her family, like a child, in charge of the Advance Directive, Medical Advance Directive, that person has more than likely made that choice. But she, of right cognitive ability, if someone else has done it without her approval and she wants to get off of it, you can tell her she can get off of it and you can have her call me.
Well, I mean, she is 100% dependent upon other people for eating and scratching her nose and doing everything. And so I think I'll talk to the hospice nurse or the person that was introduced to me as a hospice nurse and just ask some of these questions very gently.
Absolutely.
About how she got there and so forth. But I will certainly keep you in mind, Joan, about giving you a call and discussing this further.
Sure. Now realize a doctor can make a suggestion. A doctor can say, Dear, I have done everything medically I can to help you with improvement, but you're not improving anymore. And I'm suggesting you consider hospice.
Okay.
Starting point could have been a doctor, or it could have been a hospital, or it could have been a rehab. So, but it probably wouldn't be well, I don't know. I don't know the story, but we can talk about that later, Billy.
Okay, great. Thank you.
You're welcome.
All right, wonderful.
Any other questions for Joe? Well, Joe, on behalf of Breath Matters, we appreciate your time and thank you so much, because I know you're not here in Richmond and you're out there in LA enjoying the weather and everything. When are you coming back?
We come back Friday.
Nice. Well, thank you for taking some time to share with us. I appreciate it, as I always do.
You're very welcome. And so we'll talk soon.
All right. Take care.
Meeting now.
Thank you.
Elvis is
Bye.
leaving the building.
Thank you. That was a great presentation.